they're trying to get us to think that, this 1990 Bill of Rights is the same. And I'm here to tell you that I have put it in my case, but I don't have it on my notes right now, but in the Geringer case and in various other cases that I have put, they have said that the 1990 Bill of Rights Act is an ordinary law. It's a subordinate law. And the 1688 Bill of Rights 2015 New Zealand is a constitutional law. And I have also looked in the, sometimes I get a bit confused here, but I'll be better on the day, in the, you could cause this for relief, in the Cabinet Manual. The Cabinet Manual does say in there, the 1990 Bill of Rights, it refers to the 1988 Imperial Law, and it's put both of them in there. And I'm saying that it's confusing, and I'm saying that the Human Rights Commission, and together with Chris Farfoy and his declarations of inconsistency that he's brought in, and all of these things, New Zealanders are being led to believe that they have to uphold many laws that are repugnant to their Protestant laws. Now, there are 3 million New Zealanders that come under that. I don't know about the originally, when people were made citizens of New Zealand, part of their citizenship was that they swore allegiance to the Queen, and in doing so, they swore allegiance to uphold our Protestant right. Now, I will just quickly, Mr. Peter, so finally, in the short amount of time that we have, what I am seeking is a clear declaration. I've asked for 4 prayers, but what we want is something clear and concise that we can depend upon in these trying times. And as you see, we've got people burning tents outside Parliament. I have not sent all my evidence. We've got black eyes. We've got blood streaming down people's places. We've got broken bones. We're at a critical time, and I think it might be healthy for all of us. And I would just say to you, nobody's being accused here. I have not accused the Prime Minister, and I have not accused Chris Farfoy or anybody else, but I'm saying that it would be nice for all of New Zealand if we could hash this out in a courtroom that the public can see, and we can get our voices heard. We want our voices heard, and we don't want to be sidelined. And I believe under my right, under the Declaratory Judgments Act, it is my right to ask for this and to petition. It says that my right is to petition to the Queen, Her Majesty the Queen of England, and the way that we do that is by petitioning through the Supreme Court, which then goes through to the Governor-General. And we know that we've got people, common law people, standing outside the Governor-General's office singing songs and knocking on their doors and knocking on the Prime Minister's doors. And I'm saying to the people of New Zealand that this is not the correct way to conduct yourself. What you've got to do is use your right that has been promised and go through the courts and exercise that right. And this is what I intend to do. And I believe that the only people that we believe, I do believe that Jacinda Ardern, which will bring me to my second piece of my case, that I am saying, according to the Cabinet Manual, that they are supposed to, the 1990 is an ordinary law, and quite frankly, it's not really a New Zealand law. We have issues with the Section 19 that ties to the Human Rights Act of 1993 of Section 5, subsection 2, KII, where it says report to the Prime Minister, and it says that New Zealand will be bound to any international law. Now, I feel that this is a national security monstrosity. It's dangerous, and I feel that since it says to report to the Prime Minister, the only person that can address that with us is the Prime Minister. And I would like to ask, and the Minister of Justice, since he is the Minister of Justice, we need to be having that. Now, part of my case in my memorandum is that we have asked for a temporary suspension immediately on certain lawmaking that they're doing, and I've listed them there. I won't go into them today, but you can see them anyway. But I have, my case there is I'm saying to the Governor-General in the Supreme Court that presently Jacinda Ardern and Chris Farfoy, in this particular case, we are not speaking to Ashley Bloomfield or Andrew Little. We're specifically speaking to Chris Farfoy in his role as Justice Minister. He fluctuates between roles, and also Jacinda Ardern, and we're saying they're not only them. They're supposed to lead by example, and through them, none of the ministers are upholding their oath, and the specific points that we will be mentioning that they're not upholding, and it's in the Cabinet Manual. They're supposed to, under the frequent parliaments, that they're supposed to be there for amending and strengthening and preserving our right in the constitutional right, not in the subordinate right. So we feel that they are not upholding their oath in regards to that. I'm thinking that they're not upholding in the specifically I'll be speaking to is the two houses sit, and we're saying that that they're supposed to make effectual provision for the settlement of our Protestant religion, our laws and our liberties of this kingdom, so that they will not be in danger of being subverted. And we have got several people and even ministers in our own parliament that are asking for the entrenchment of the 1990 Bill of Rights, which comes along with the Human Rights Act, which comes along with Section KII, that New Zealand will be bound forever to all international instruments. I don't even know how they could even write a law like that and say that they're making effectual provisions for the protection of New Zealand people. I really don't. So I think they should explain. Now it says here, under the limitation of the Crown, it says here that they will prevent all questions and divisions. So there should never be a time, and we'll go back to what Sharon was saying, which was very important, of the how do you say that, Sharon? The Komarama Conference, where it says that all the chiefs had said that you would not govern these people by their race, and that is exactly what they're doing, and there are questions about that, and we will be asking those questions. Sharon wants to say something. Quickly, Sharon, what do you want to say, dear?
The reason why, as a native, I am native. I am not a refugee to New Zealand. We are natives under the Queen, under the 1688. That's the question I want to ask. I want asked and answered.
That's right, Sharon. That's what you're saying, because they have been listed as refugees in their own country, and they want us to go under thus inalienable rights, which is an American law, and our right comes under indubitable right. And indubitable right cannot be questioned, and this is what we were promised, indubitable right, not inalienable right as refugees.
Catherine, I'm sorry to cut you short there, but I'm going to have to, I'm afraid, because we've sort of run over time anyway, and thank you, Sharon, for your input too. I just wanted to say by way of an immediate response, Rebecca and I will be sitting down and thinking about what you've said to us today. I've taken some notes, and I think, I'm not sure because I'm not with Rebecca, but I think
I've taken extensive notes.
Taken some notes as well. So that would be, we have a record of some of the things that you've said, and we'll be reflecting on that and considering what we should do in responding now to the court, which is something we have to do obviously by Friday this week. So we will be getting on to that. And in fact, I think it's Friday for a response, Rebecca, and tell me if I'm wrong. And we also have to file a memorandum possibly tomorrow, I think, if I've got that right. Is that right?
That's right. So the case management conference with, I think, Justice Palmer again is on Monday at 10 o'clock. And the normal practice, which applies in this case, is that we would, and Catherine, you would, if you would like to, file the memorandum in advance of that.
I have already filed my memorandum, but your answer was that you didn't comprehend mine, and I would just like to say that I'm very.
And this conversation has made much clearer.
Yeah. Oh, okay. But I'm very concerned about going to the court because, as you all know, that none of us are lawyers, and we're hoping to find the thing that is concerning us the most is who's coming to the court, and it's hard for me to speak to the judge because I'm not sure if we should be having this argument in the court about who's coming and who's not coming. It's my limited understanding that, and you can correct me if I'm wrong, that we're supposed to go to the court and we're supposed to say to the judge, this is who's coming and this is the time frame or some. I'm a little bit unsure. I'm not unsure about my case, but I'm a little bit unsure about court protocol. And when I'm asking for assistance, I'm not asking for assistance in my case, asking for assistance in court protocol. Can you please just tell me that, please, before you go?
Yeah, he's better now.
Just to respond to that point, Catherine, and I understand the concern. And I think the purpose of this call is to, as I say, try and get a better understanding of what your claim is about, and also to try and explain some of our difficulties in understanding the claim. So I think we've sort of gone through that. In answer to your question about who gets to appear, who would be there as witnesses and so forth, the discussion we're having now is something that we might be able to agree on those points or on other points. But even if we did, we'd have to go to the court and get the court to say, yes, we agree. And so that will be the way things will work. If we don't agree, and we may not agree on whether we need the Prime Minister here, for example, just saying that as an example, I'm not saying that we don't at this stage, but I think it's likely that we don't. But if we don't agree, then we'll go before the court and we'll have an opportunity to say why we think the Prime Minister doesn't need to be there or maybe even shouldn't be there. And you'll have an opportunity to say to the court, no, what Mr Gunn says is completely wrong, and the Prime Minister definitely does need to be there. And then the court obviously will make a decision based on the view they take of our various arguments. So don't worry that we're going to agree to anything here that you might get stuck with. If you disagree with anything that we have to say, then obviously we can put that before the judge, and that's the way these things always work. Can I just say a couple of other points before we close that out? Firstly, you referred to some confusing aspects to the New Zealand law and to the New Zealand Constitution, and I don't think that we would necessarily agree with you or disagree with you on that. There are some confusing aspects to it, and I think for some people, and some of them are lawyers actually, it can be a bit hard to understand that the Queen of England and the Queen of the United Kingdom is different, but the same person as the Queen of New Zealand. And those are difficult concepts, even for constitutional lawyers, I think, to understand. I think we certainly agree there are difficult aspects to the New Zealand Constitution, and there may be some aspects that may be able to be clarified by us or you that would help, and that's something that we'll also have to think about and see what we can do in that respect. Because again, if we can avoid the time and effort and money that will be involved in going to court, then we should be doing that. So that's what we're going to be doing now. Thank you for everything you've said and the effort you've put into explaining your position. We really appreciate it. We may not agree with you at the end of the day on everything or on lots of things, and I don't want to pretend that we will necessarily, but what I will say to you is we'll go away and we'll have a hard think about everything you've raised and see where we get to on it, and we'll see you. You'll see our memorandum and our response to your claim before the case management conference on Monday, and then obviously on Monday there'll be an opportunity for us both to talk to the judge about things and how the case is going to unfold from there. I understand what you're saying about not being lawyers, and I mean there may be some benefit in talking to somebody who's a lawyer or trying to get assistance through citizens' advice. Those sorts of options are worth considering, I think. But those are decisions again for you guys, and I can't give you advice because I'm a lawyer for the Crown, and I can't give you legal advice. That would be wrong for Rebecca or I to try and do that. So those are issues for you to consider. So can I say thank you again very much for the time and the effort. We have appreciated it. It has been helpful, and we'll go away and have a think about things now, and we'll do our best to come back with a response that makes sense and sets out the Crown's response as clearly as we can.
Oh, that's very, very wonderful. It's been lovely to... I think it would be better. I was a bit nervous on the last... when we met at the court, but I'll be a bit better now because I've met Ms. Rebecca and I've had a chance to talk with you.
Yeah, I still get nervous in court, so that doesn't surprise me at all. Everybody does. Don't worry about that. It's just and the other thing that maybe we could both think about is what are we looking to get out of these proceedings, and that's the question I think we should be asking ourselves. What are we hoping to achieve? And maybe I think you've already thought about that, but maybe some thinking about that too.
We are asking for an urgent temporary suspension of all laws that affect our constitutional right. That would include the He Puapua, certain United Nations laws, KII, any of that. We're asking for a temporary suspension until we've had our voices heard. So we're going to be asking for the judge for an immediate suspension, and including on Marsden Point decisions that they're making, and we will be filing for a temporary injunction immediately on that, because we're happy to let these court proceedings drag out for a year or 100 days or whatever time they want. But in the meantime, we're going to ask for an immediate temporary injunction by the Governor-General. I don't know what my legal status is there, but I'm going to be asking for a temporary relief to the public to just let everybody take a rest for a minute. And I'm going to be asking for that from the judge immediately on Monday. And I will be filing an extra memorandum before Friday as well, explaining why we are requesting a temporary immediate injunction on that. Now, if we can get that, we would be happy to not be so stressed about whether the Prime Minister comes or not, or when, or having meetings to discuss. But at the moment, New Zealand is at critical levels. The people are very, very stressed. We don't know what they're going to do. And I'm going to ask for the court for some temporary relief of that for the public of New Zealand, while Ms. Rebecca and yourself and whoever we engaged in talks that we can ask, do we need to take this to court or not? So I'm happy for that, but I am going to be filing that this week. I'll just let you know, and I will send a copy to you.
All right, that's helpful to know that, and thank you, and that's obviously something you can do. Well, look, can we leave it on that basis at this stage, Catherine, and everybody else? Thank you once again for your time. We better sit down and have a think now about how we're going to respond to all of that, because we've got to file these things and meet the timetable if we possibly can. So we'll spend some time and energy on that now, and we might encounter you next on Monday, I think.
I think so. Thank you so much. Can everybody just say goodbye to you, because they're so happy to meet you? I'll let everybody start from Diane, Jodie, Maxine, and then Sharon. I'll let them say goodbye. And from me, goodbye and thank you so much. And we know we're in competition with you, and we're going to fight the fight with you. And so we know you're fighting against us, and we're fighting against you. But we'll try to do it in a friendly and lovely way with you. Okay, goodbye from me, Catherine. Okay, Diane.
Okay. Lovely to meet you.
Thank you.
Thank you.
Thank you.
Rebecca.
Thanks, everybody.
All right, see you later.
Bye.
Bye.
Bye. Thank you.
Thank you.